Hi, it's Roland Jones. This is a slideshow on basic preference law. It's not um, specific advice on your matter or any particular case, just to make sure. Okay, I'm going to be going into a general discussion of preference laws, why they exist, and what the defenses are. So, why do these crazy laws exist? That's what most of my clients are asking me. There are two basic principles: equality of distribution and discouragement of a race to the courthouse. So what does that mean? Equality of distribution is the basic purpose of bankruptcy law. There's an insolvent debtor with not enough assets to pay everybody, and so we want creditors to get paid in a fair and pro rata way, since not everybody's going to, in fact, no one can get paid in full, although except for maybe unsecured creditors and some other creditors. But unsecured creditors have to share usually on a pro rata basis. And so the basic theory is, well, there are some folks that got paid right before a bankruptcy case, and most creditors theoretically didn't get paid. And so most creditors get paid well after a bankruptcy is filed, and usually it's cents on the dollar. So we're going to look back at those that got paid 100 cents on the dollar right before a bankruptcy, and make sure that they weren't gaming the system, and that they weren't preferred in some way by the debtor. That's the derivation of of preference law. It's just preferred. So they were the theory is that these creditors were preferred and treated specially. So we're going to take a close look at exactly what happened there. It also discourages a race to the courthouse theoretically. So the theory is, well, if creditors know that they're going to have to return the money if they act very aggressively right before bankruptcy, then theoretically they're going to think twice and slow down and be good creditors, whatever that means. So and the theory is, well, we don't want to dismember debtors right before bankruptcy. Why? Because it has the same issue. It's the same issue as equality of distribution. You want the debtor's assets to be available to all creditors, not just to some creditors who can get there first and fastest. So that's the basic theory behind the preference laws. I just have this slide because you have to know where preference law comes from. It comes from Section 547 of the Bankruptcy Code. So this controls or addresses what is required in a preference case and what the defenses are and so on. So this is statute. This is statutory law, but a lot of this has been interpreted by many, many, many cases over many years to flesh out the statute. But this is 547. This is part of 547, and I won't spend a lot of time parsing it. What is a preferential transfer? Well, to see what a preferential transfer is, first of all, you have to know that there's a preference period. So what's that? This is what it is. Generally speaking, it's 90 days before bankruptcy is filed. You can see the start of the preference period here, and then the 90-day period, and so on. It can be longer than that, but to keep it simple and for our purposes, most of the time it's going to be 90 days. After the bankruptcy is called the post-petition period. The period before the bankruptcy is called the pre-petition period. So the preference period is 90 days in the pre-petition period. That's sort of a "you are here" diagram, sort of just to show you that theoretically you got paid in this period if you were being sued for a preference. Um, like I said before, the preference period may be longer, but we're not going to go into those complexities of this on this slideshow. Just to continue on what a preferential transfer is, a preferential transfer is one where a creditor is being paid 100 cents on the dollar at a time when the debtor is insolvent. So anytime a creditor is being paid during the preferential period, 100 cents on the dollar, it's really preferential. Even if there are defenses, even if there's a safe harbor, such as the ordinary course defense. But the fact is, totally innocent creditors, even if they're paid by accident, are still being paid, are being paid preferentially and receiving preferences. Why? Because the debtor doesn't have enough money to pay everybody. So, by definition, if you're getting paid during this period and the debtor is insolvent, which means it owes more money than it has, to put it simply, then you're doing better than these guys who were paid in the post-petition period. So the definition of a preference is you're getting 100 cents on the dollar when the debtor really can't afford to pay 100 cents on the dollar if he's going to pay all creditors. So that's really the definition of a preference. It has nothing to do with an intentional design by the debtor to prefer you. So that's a big misunderstanding that people have. Nonetheless, there's what's called a safe harbor, and the safe harbor, one of the safe harbors, is called the ordinary course defense. And what that means is that if you were paid in the ordinary course, whatever that means, then that's a safe harbor from being sued for a preference, and that's a defense to a preference. So how do we show ordinary course? We look at the base period, which is a year or more or less, depending on the facts, prior to the 90-day period, 90-day preference period, and we compare those two periods, and we're sort of deciding, hey, you know, did anything change during those two periods? Were they very similar? If they were very similar, the argument is, hey, it's business as usual. Nothing changed. We always got paid in 30 days. We got paid in 30 days in the preference period. And so it's business as usual, Your Honor. There's no indication that we were paid in some special way, that we were paid differently, that anything changed. And so the courts consider that evidence of an ordinary course, a valid ordinary course defense. It's much more complicated than that, but that's sort of a very thumbnail summary. Okay, and I'm going to go into more detail now. So defenses to a preference claim. What are the defenses? I'm going to go into three very basic defenses. There are many, many, many other defenses, but for the purposes of the slideshow, we'll go into three basic ones. Okay, the first one I want to talk about is a contemporaneous exchange defense. That's sort of a fancy way of saying you got paid at the same time that you delivered your product or service. And theoretically, this is the theory behind it, you know, that there is no diminution of the estate because the estate was replenished. I actually don't buy that theory, but it doesn't matter. The theory is that this isn't a preference because it was paid immediately and no debt was created. There was no antecedent debt. That's the key word, because the plaintiff requires that there be an antecedent debt. That's in the 547 statute. So here, you know, if you ship bananas on Wednesday and you get paid on Wednesday, really there's no credit transaction. There's no debt. Well, that's what I just said. I got ahead of myself a little bit. Yeah, I mean, that's the theory. I have problems with that, but you know, that's for another slideshow. that I'm doing my objections to the preference laws, but it's not appropriate for this one. New value. Intent is an important issue because that's part of the code. So there are two elements to contemporaneous exchange. One element is that the parties intended that the exchange be contemporaneous, and this can be you don't have to find out what was in the head of somebody or the heads of the two parties. It can be inferred from circumstantial evidence, and this is it's what it sounds like. Was this the intention of the parties to exchange the product or service for immediate payment? Whether it was substantially contemporaneous. So it doesn't have to be, in other words, what courts have interpreted that as saying it doesn't have to be the same day or the same minute or the same hour. Courts have held that exchanges, money for services or product, were substantially contemporaneous, even though the payment was made a week later or even 2 weeks later. I don't think I've ever seen any case that allowed this defense where payment was over 2 weeks. Anyway, I don't recall seeing one. So basically, it's pretty close to the exchange of the goods or of the product or services that you need to be paid. There's a ton of case law on this. Again, there are over 300 bankruptcy courts in the country, and they all have different opinions. But that's a fair summary of this particular defense. Okay, this is the granddaddy of all defenses, and it's the one relied on the most by people. It's also the one that is really the most problematic in a way. It's very fact specific, which means that the court is supposed to look at all the facts and circumstances, and it's the one that drives. This is the defense that drives people absolutely crazy because every single client I have comes in and says, "Hey, it's ordinary course. What are we even doing here?" And the fact is that ordinary course is actually very difficult to win a case with successfully. So why is that? Why is it so hard? I'll show you why. Okay, the first thing you have to know about ordinary course is that basically, like I said earlier in the slideshow, we're going to look at a baseline. So in other words, we look at the preference period, what happened there, and then we're going to go back and look at a year or more or less. We're going to create a base period, or we're going to compare what happened before to what happened in the preference period, and hopefully they're similar. Okay, so I'm going to show you an example of an ideal situation for an ordinary course defense. There was a uniform pattern of payment in the base period, and that continued into the preference period. Okay, so I'm going to flip through these slides fairly quickly and then stop at some slides. You can tell the invoice is paid in 11 days. Again, invoices are paid in 11 days. This is how we usually prove ordinary course through a spreadsheet. Days to pay on the right. That's the most important column here. As you can see, pattern continues. Okay, I'm going to stop here. So, what happened here? These people always pay in 11 days. in the base period and the preference period. So this is a very nice ordinary course defense. Nothing changed, nothing out of the ordinary. The ordinary course defense is about consistency. Nothing changed. And I could say that the implication is that there's circumstantial evidence that if something changes, if there's a wire, if there's a very late payment, if there's a very early payment, there's a circumstantial evidence, or the theory is there might be circumstantial evidence that there was a preference, that there was arm twisting, that somehow this vendor, this unsecured creditor, somehow got an advantage. As I said before, it's a very fact-intensive analysis, and this is one of the factors. But consistency is very important, and basically what it shows is that there's no evidence that anything unusual happened here. No evidence of any particular advantage. They got paid in 11 days. They always got paid in 11 days. Just looking at this particular pattern and ignoring any other factors. Okay, so this is, do I ever see consistency like we saw before? Almost never. This is what usually happens in a case and what it looks like. Okay, so 11 days and 8 days and 10 days and then 20 days. So the issue for both the lawyer for the defendant and the lawyer for the plaintiff is, what about that 20-day payment? Are we going to say that's, obviously the other side is going to say, hey, that's not ordinary. All of a sudden they're paying in 20 days, 10 days later. Is it ordinary or is it not ordinary? It's more problematic for the defense because we have to argue that it is ordinary. How is it ordinary? And this is what lawyers get paid for. If it's 11 days consistently before and after, that's easy. This is when the fun starts, when there is variation in the 90-day period. So all this says is may not qualify or may qualify. It's just more of a challenge because there was deviation from the base period. One of the ways that we argue for ordinary course is to take an average, or the plaintiff argues against ordinary course, is to take an average of days outstanding in the base period. Let's say 11 days. Obviously, the average in the perfect case was 11 days. And then we take an average of days outstanding in the preference period. And then we compare those two averages and decide that can be helpful to show, hey, they're pretty close. There's not enough to really show that the ordinary course defense does not apply, and the ordinary course defense should apply because they're pretty similar. In the same way, we're going to look at ranges of payments. In some circuits, some courts find this to be more convincing than averages. For example, if you were paid between 20 days and 60 days in the base period, and then you're paid in between 30 and 40 days in the preference period, I would jump all over that as your defense lawyer and say, hey, these guys were paid within range. They were paid within range. That's the important argument. Your Honor, this happened before in the base period. It's not unusual, and that's a good argument, and that's recognized by a number of courts. Of course, you have to look at other factors, and there are other complexities. This is just a very simple overview. But obviously, if your payments are within range, it's helpful. It's helpful. Move on to an important issue, which is collection pressure. Collection pressure is the big red flag in the preference period. And why is that? Well, the reason collection pressure is bad is because it's basically an indication of preference. It's indication that that the transfer was not in the ordinary course. Let's say there was never collection pressure before, and all of a sudden we find out that the debtor's about to go bankrupt. So we threaten him, we hire a lawyer, twist his arm, and he pays us. Okay, so we're getting a preferred payment, and we're also doing it consciously, not really to get an advantage over other creditors, but we want to get paid. But we are getting a preference, and it's arguably maybe not in the ordinary course. As you can tell, I hedge a lot because I'm a lawyer, and that's what we do. But I'm also hedging because each case is just so unique that you just never know in the totality of the factual pattern what's going to be ordinary course and what's not. But collection pressure doesn't help. Here's an example. Payment is overdue for the order dated XYZ. Please send immediately. Hey, that's like a normal email that probably was sent, 18 times or 1,800 times during the base period and another 1,800 times during the preference period. So that doesn't raise a lot of red flags to me. If that's pretty ordinary between the parties, it's not really heavy pressure. This is more of a red flag. Dear Mr. Smith, we have not received payments for invoices. We will not ship any more products. Okay, so here's some fairly serious arm twisting. Is this going to take it out of the ordinary course? I don't know. I mean, maybe these guys exchanged emails like that. Again, 1,800 times during. Maybe this is how they did business. Maybe they're always sending emails like that during the base period, comparison period, and the preference period. Maybe it's not unusual. That would be my argument. The other issue is, well, did they not pay, and did you actually stop shipping? And then all of a sudden they paid? Did this email cause a transfer? Or was it just ignored like usual and you got a payment, a month later? A big issue is, did the collection pressure actually result in a payment? Or did they pay like they always paid? And this was just ignored. So there's a lot of complexity even here. Although when I see this, I'm not happy to see it, and it is a red flag that has to be dealt with. And we have to dig into the facts and see what happened here. All right, if there's no prior history, so you just did a one-off transaction, then you look at the case law says that you look at the terms of the contract. You got paid within terms under the case law. You might be okay. You might have an ordinary course defense. If they paid, very, very late, you might have a problem. Okay. The second prong of the ordinary course defense is called the industry standard. This can be used instead of looking at the history of the transactions between the party, or can be used in conjunction. In other words, it can be a standalone defense. So, to simplify it, basically what it is what it sounds like. Where the payments, did the payments comport with the standard in the industry? If you got paid in 60 days and the debtor is in the, to make it simple, let's say in the electronics industry, and you're in the electronics industry, is 60 days normal for that industry? The problem with this defense is there's a lot of fighting about what industry should apply. There's much less case law than ordinary course, so it's harder to predict what a judge will do. And the biggest problem is typically an expert is required to give an opinion on what the industry standard is, and so it's expensive. This is one of the reasons we form groups, because we can split the cost of an expert, and that's really, really crucial. Experts are very expensive. An affidavit from an expert and a report, you're looking at $5,000 easily. If the expert gives testimony, if he's more and more involved, $5,000 turns into $10,000, turns into $20,000, and unless these costs are divided, or unless the claim is very, very large, it doesn't make a lot of sense to use this defense. I sort of touched on that. There's litigation as to that. Let's say the debtor is in a different industry from the defendant. Um, there's also a fighting as to how finely to define an industry. A plaintiff, if I said the defendant's in the electronics industry, I'm sure a plaintiff would say, well, that's much too broad, and it creates fact issues. The defense creates fact issues, which are always expensive to resolve. That's just my opinion. Usually, you got to get an expert. Although there is case law that says that the officer of the defendant can testify, but just using common sense, the officer of the defendant is probably not going to have a heck of a lot of credibility with the judge. Obviously, um, he's biased or she's biased. Um, so, can that be done according to at least some case law? Yes. Will the plaintiff object to it? Probably. Will it have credibility? Maybe. Who knows? Each case is different. Um, but that's an important. The expense in hiring an expert is an important issue in this particular defense. Okay, the third defense I'm going to talk about is called a new value defense. This is also, maybe it's not the granddaddy, I don't know what to call it, the grandmother. Anyway, it's another very common defense. This is the statute actually, this is the statute defining what new value means. But the point is, it's statutorily based, and you can Google new value defense preference case, and you'll get the statute in about 10 seconds. So how does this thing work? Okay, you get a check, first check, let's say 10,000, and during the preference period, so that's theoretically a preference. Then you deliver product worth, let's say, 20,000 right after you get that check, and then you get a second check for I don't know. I'm losing track of what I'm saying. But let's say 50,000. It's called a subsequent new value defense for a reason. You probably, let's say you were not paid for the product or service that you delivered or rendered after that first check. You're probably going to be able to set off the value of that product or service against the first check. So, it's an extremely effective defense. It's also a very easy defense to show sometimes, but I'll show you why it gets complicated later. Unfortunately, you will not be able to set off the value of that product or service against the second check. Why? Because it's not subsequent to the second check. You delivered this product or service, or rendered this product or service prior to the second check. So it's useless with a second check. And so it can be frustrating because there could be a lot of value that you deliver and not get paid for, and you can only set it off against the first check. And you can't sort of, keep some of it and then apply it to the second check. It's not the way it works, at least under the current case law. It gets complicated, and we use a spreadsheet to figure it all out. What does the spreadsheet look like? I decided to show you. So in the right-hand column, you're going to see sort of a running balance, and that's how we analyze this stuff. Paid new value. If you got paid for your service or product, most courts say you can't use it as something you could set off. This is kind of controversial. There's been a lot of litigation when you use paid new value. There's also litigation. Let's say you're not paid during the preference period, but let's say you're paid later in the case somehow. which I have seen happen. Can you use it then? It's controversial. So we're looking at unpaid new value. Stages of a preference case. It's a quick overview and what happens during a case. Like any lawsuit, complaint, answer, there's what's called a 26F call between the parties to discuss discovery and usually settlement. I've never seen a case settled during the 26 conference call. It's very early in the case, and there's too much posturing by both sides. Pre-trial conference is really a misnomer. It's really a status conference. There's usually 5 to 10 status conferences before there's actually a pre-trial conference. In the case, scheduling order sets out the deadlines, such as when discovery is going to close and when you can file a motion for summary judgment, that kind of thing. Discovery is exchanged after the scheduling order is issued, which means parties are going to be serving each other with discovery demands, maybe deposing each other. Usually often there's mediation. In Delaware, it's mandatory. And usually that comes before a motion for summary. Usually it comes actually before discovery, or discovery is frozen to get that done to save everybody some money. And then there's a trial schedule. Trial is a little bit rarer than a lightning strike in the preference world. So I don't see too many of those. Okay, I already described that. I'm not going to go into too much detail for this slideshow. Suffice it to say that there are demands on both sides, and they must be complied with within 30 days, unless there's extensions agreed to. Settlement process is very, very important because all these cases are settled. The only question, or dismissed, or I would say all, but the vast majority are settled or dismissed. And the question is, the most important question is for you is, what's the number going to be? Is it going to be 2% of the claim amount, or is it going to be 80% of the claim amount? That's sort of where the parties start out. The defense starts out with 0 or 2 to 5%. The plaintiff starts out almost always at 80 or 85%. So where is the case going to settle? This is controlled, in my opinion, by the strength and expertise of your counsel. I hate to say it, but that's a fact. I've seen, and why is that? Because counsel is good at knowing what the leverage points are in a case. But I think I'm just going to stick to describing what a position statement is. Position statement is a tool that we use and is fairly common. It's basically a legal brief. It's a summary of all your defenses and facts in your case and appropriate exhibits. So the purpose of a position statement is to say to the other side, hey, let's not waste money fighting about this. Here's our position. Why don't you please just dismiss the case? And the plaintiff will say, well, thank you very much. I've reviewed it, and here's what's wrong with your defenses. So I'm willing to be somewhat flexible in my initial offer, but there are still problems. And so it starts the ball rolling on negotiations. That's basically what it does. Sometimes I've had a case dismissed just on a position statement. Thank you very much. You're right. Case dismissed. Other times, plaintiffs come back and say, your position has no merit whatsoever, and I've had everything in between. But it does get the ball rolling, and it's very important. I have found in 10 years or over 10 years, actually well over 10 years, or like 18 years, I found it to be the most cost-effective way of resolving cases, even though it's a cost that has to be borne earlier in the case. It prevents 1,000 paper cuts. Court-ordered mediation is the next step, but I think the position statement, which by the way gets converted into a mediation statement, is probably more important. Usually done within 3 months of retention. Usually earlier, actually, usually 1 or 2 months. Okay, I got ahead of myself again. Yeah, so mediation is ordered. Actually, in Delaware, it's mandatory. I think it's ordered earlier. But some courts will wait and see the case is resolved. And if not, a lot of courts order mediation. Said that already. Yeah, just to repeat that, it's important. In a lot of cases, you have to do a position statement anyway. It's called a mediation statement. So you may as well get it done earlier and maybe avoid the whole mediation process. Again, more cost that you want to avoid. Yeah, if you want to do a motion for summary judgment, the rules, as I understand them, and in practicality, require that you wait until after discovery, and usually mediation freezes the process anyway. Or in practicality, you want to get the case settled, so you're not going to spend money on a summary judgment motion, even if you have a strong enough case to file one, until well after mediation and multiple attempts to get the plaintiff to see reason. Anyway, that's coming from a defense point of view. I'm sure plaintiff counsel has a different opinion. Well, motion for summary judgment is important because it's much less expensive than trial. If you can't get the plaintiff's attention with a position statement and you're just not getting anywhere, you're just not getting any love, then you have to file a motion for summary judgment. I don't even like filing it. I would serve it on the plaintiff first. I really, I think the main purpose of a summary judgment motion is to just tell the plaintiff, hey, wake up. We've got a very strong case here. You've got to settle this case, or you're going to spend more money fighting a summary judgment motion. You don't want to do that. So let's get this, let's stop dancing here and settle this case. Of course, if the parties are just deadlocked, the only way to get rid of this case is summary judgment, then, the very, very last option is to spend money on a summary judgment motion. If you're just, not getting any reasonable kind of reaction, which, by the way, I think is pretty rare. Plaintiff counsel are, typically, in my experience, most of them are sophisticated, experienced, and if the case is strong, they're going to settle it or dismiss it. Sometimes, very rarely, they're not, and we've got to bite the bullet. Outcome of a preference case. Again, depends who you're using as counsel. If you're using yourself as counsel, unless you got a real simple case, I will refer to the old adage, if you represent yourself, you've got a fool as a, is it a lawyer or client? You have a fool as a client or a fool as a lawyer? I'm not sure. But anyway, if you represent yourself in a complicated case, you're basically crazy because you're not going to get anywhere, in my opinion, and it's going to cost a lot of time and a lot of aggravation to proceed. It's just my opinion. If you want to represent yourself, knock yourself out. Well, that's to restate the obvious. I think I've already said that. I already said that too, but it's important to recognize. Why is that so important? Because when people are sued, they're terrified. Oh my God, we're looking at 20,000, 30,000, 40,000 legal fees. We better just cut a check now. But the fact is, it doesn't cost. If you take a case to trial, almost any case, you are talking about 30,000 and up in legal fees, and well up in legal fees, especially a larger case or a more complicated case. You're talking about 30 to 100,000 in legal fees, but they very rarely go to trial. That's the key point to remember: is that these cases are settled because the plaintiff doesn't want to spend a ton of money on a case that it has a good chance of losing. And so the point is to focus on getting. The point is that the legal fees are not as scary as most people think. Why? Because I don't really have to spend a lot of time on a case. The time I spend typically is doing a position statement, and then if the case is strong enough, getting a decent settlement or even a dismissal. I don't spend hundreds and hundreds and hundreds of hours because it's just not required in the vast majority of cases. Okay, a couple of words about the Greenfield Energy Services case. I'm not going to say too much about Greenfield. These are some of the major deadlines. You can rewind if you want to see it again. Very experienced bankruptcy judge, Judge Gross. A little bit of a timeline. I always find this interesting, and it can help sometimes in forming a group and in also analyzing group-wide defenses. So most of these cases, you can see Texas, Louisiana, nothing from Delaware, which is always interesting to me since everybody's got to trudge over there. I find that to be very unfair, but that's for another video. That's for my other video where I rant and rave, but with cause. This is interesting, and it's always good to know. Are you a tiny fish, or are you like all the other fish? Here, if you're under 50K, you're like all the other fish. It's good to know because sometimes when I look at this, there are very, very few cases under 50K or even under 100K. And so what does that mean? Plaintiff's not going to want to spend a lot of time on this case. So it's leverage. It's going to be easier to dismiss. It's very comforting when I'm a tiny fish. If I'm representing a defendant here that's over $1 million, not so comforting. Why? Because there aren't many cases like that here. Plaintiff is going to be all over that case, or whatever number of cases are over $1 million. What would you do if you were a plaintiff? You'd spend your time where you're going to get the most buck for your money, the biggest bang for your dollar, and that's going to be, in the bigger cases. If every case were over $1 million, then you'd be spending, time on every case. So yeah, it's just good to know. This is important for the industry defense. What's your industry? Here, a lot of people are in the construction industry. A lot of people in transportation. I'm not clear that this is the industry of the debtor. It doesn't sound like it is. So, there are issues. It's interesting to know as far as a group goes, and it's interesting to know because as far as an expert goes, I may reach out to people that are not in the group, to lawyers that are representing other defendants and getting together for an expert for industry standard if that's necessary, or if it's worth bolstering the other prong of the ordinary course defense. So, it's important to know what's going on in the case because you can always use it. Yeah, so that's all I have to say. This is just restating, this is very, very general information. It's not advice on your particular case. I'm willing to talk to anybody at no cost on the telephone to go over their facts and give that defendant a concept of the strength of their case based on their individual facts and what I think the cost is going to be. It's fairly easy to, I would say fairly, it is within the range of predictability. I don't even know what that means. What do I want to say? I think I can predict, at least to some degree, the outcome of a particular case based on the fact pattern and what the costs are going to be. I guess that's the most lawyerly thing to say. And with that, I'll sign off.